recognize the new member of our committee, the gentlelady from Missouri, Ms. Hartzler.
Thank you, Mr. Chairman. I appreciate you letting me sit in here today and participate in this very important hearing. And I certainly appreciate, Dr. Michaels, the leadership you provide to keeping our workers safe across the country. But as you do the enforcement, I think it needs to be coupled with common sense. And I was just wondering your opinion about some citations that I've heard about. So do you think that a company should be fined thousands of dollars because the emergency eye wash station, the water was too cold?
You know, I'd have to look at the specifics. Obviously, that does seem questionable, but you know, there are lots of issues in any one inspection, and the facts drive that decision. And so I'd be happy to look at that.
How about having a yellow, being fined thousands of dollars because you didn't have a yellow line painted 10 feet from the edge of a flat roof?
Again, the same thing, but you know, we have rules about protecting workers up on roofs, and we have too many fatalities. So we expect employers to follow that. If that were the only reason they got fined, we'd have to look at it very carefully. But,
or how about an extension cord that's is in the wrong place?
Well, if the extension cord is frayed and someone could be tripping over it, we'd have to, again, it's fact specific, but I understand your concerns.
Yeah, my concerns are, I was wondering, you said you had the field manual, so how much discretion is given to OSHA employees when enforcing the regulations? If they find something, are they able to say, hey, why don't you unplug it, move it? Do they have that authority? Are they supposed to just slap them with a fine and $6,000 right there?
No, the discretion actually is with the area director. The inspector is supposed to report what they see, and then the employer is supposed to meet with the area director and talk about what are the implications of this. Had they, in good faith, tried to eliminate the problem, things like that. And the area director has a great deal of discretion around the fine.
So they have the discretion to totally eliminate it?
No. Here's the reason. If we had a policy where we said the first time we see a problem, there's no fine, then everybody would say, okay, we don't really need to do anything until after we're caught once. So we can't allow that. But we think we have a tremendous amount of discretion. The other thing we tell small employers is, look, we have a free consultation service. Once you get into that service, you're exempt from inspections while you're using that service, and that's what we want employers to do.
And I do commend you for that service, but I think it doesn't make sense to go ahead and find it. In my case, I mean, the stories that I've heard, I think it's almost like extortion. Small businesses are told, okay, you're going to be fined for a non-serious violation. That's what we're talking about, $6,000. But if you agree not to appeal it, if you pay today, it's only $2,000. How's that different from extortion?
Well, you can't be fined $6,000 for a non-serious violation. We have a very clear step system of penalties, and the maximum penalty for a non-serious violation for the first time is quite a bit lower than that.
Well, still, thousands of dollars. If you're a family-owned business, that can have huge implications. So I guess another question, you talked about your whistleblowers. How many inspections are a result of the employee who's been fired? Do you keep track of that?
I don't think we do. We keep track of health and safety inspections that come from complaints, and then we have a separate database when a worker has alleged that they've been retaliated against, and we'd have to match the two if we get both sets of complaints. But I don't know the answer to that.
I would encourage you to keep track of that, because while there may be certainly legitimate cases, and we want to protect the worker in those cases, but then other times, would you concede that sometimes maybe retaliation does occur? Somebody got fired because of incompetence or something else, and then they're going to get back at them. We'll call OSHA, and boy, they'll come in and get them.
We often, when we investigate allegations of retaliation, we often find that the retaliation that's being alleged didn't occur, and the retaliation or the firing occurred for other reasons. And we do an independent investigation of those, and that's a common finding. On the other hand, we also find that workers have complained about safety and health reasons, and then they're fired. And so we have to take the allegation very seriously, but I think we do a good job parsing that out.
Sure. Well, I just disagree with you, I guess, saying that you think that just doing away with the fine for something that's non-serious, that the company wouldn't, respond. I think you would have served your purpose in raising an awareness of a danger, but if it's something that could be fixed easily, the government should work with businesses, especially family-owned businesses, instead of treating them like criminals and coming in and with a clipboard and we gotcha type mentality. So I think OSHA and all government, we work for the people, and OSHA should have that attitude when they confront the businesses.
And we do. We have a category of de minimis violations. We're ones where we issue no fine. But if someone could be hurt, we feel that there's some penalty that should be associated. It could be less than $100, but there has to be something associated with that. But again, we stress for these family-owned firms, we can help you for free. Let us do that before we send an inspector and before a worker gets hurt.
Sure. Thank you, Mr. Chairman. I yield back.